This is Marlene Yvette again, and I'm back. I was actually going over the Texas Code of Judicial Conduct. Again, you can Google this document and print it out. It's amended by the Supreme Court of Texas through August 22nd, 2002. I'm going to go over some of this, but I want to go ahead and start with terminology so that we can understand that there is actually a difference. We talked about abuse of discretion and what a judge can use their own discretion to determine and what they can't. It goes over the terminology, and I'm just reading this to you. It says shall or shall not denotes binding obligations, the violation of which can result in disciplinary action. Should or should not relates to aspirational goals and as a statement of what is or is not appropriate conduct, but not as a binding rule under which a judge may be disciplined. May denotes permissible discretion, or depending on the context refers to action that is not covered by specific prescriptions. Again, may is permissible discretion. Should or should not is aspirational goals. Shall or shall not denotes binding obligations, the violation of which can result in disciplinary action. And so ultimately, when they talk about patterns of improper activity and the effect of the improper activity on others or on the judicial system, this is the issue that we have. The things that I'm complaining about or that I have very serious issue with Judge Miskell and the judges of the Collin County system there is the things that they shall do or shall not do that they have all continued to just do because I guess we're Collin County, we can get away with it. Judges are supposed to be arbitrators of facts and law. A judge shall comply with the law. That's Canon 2A. And should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary, not a mockery of it. A judge shall not allow any relationship to influence judicial conduct or judgment. That means also relationship with other judges that are carrying their personal vendetta throughout the courthouse. A judge shall not lend the prestige of judicial office to advance the private interests of the judge or others, nor shall a judge convey or permit others to convey the impression that they are in a special position to influence the judge. Canon 3 talks about judicial activities, adjudicative responsibilities. Canon B1, 3B1 says a judge shall hear and decide matters assigned to the judge except those in which disqualification is required or recusal is appropriate. That definitely clearly is my case here, but I haven't wasted my time to file recusal motions because ultimately the way that they operate in Collin County is all the judges have each other's backs anyways, so all I would do is get the next judge that would find a way to do the same thing. Don't have the time, the money, the desire for any of that, trying to live my life, care for my children, be a good mom, and not have to focus on being a full-time attorney. When they are family law specialist, Miskell is, and she knows how to do her job, she's just choosing not to, and choosing to commit crimes. Another thing, it says a judge should be faithful to the law. They should be, which that's kind of interesting that they're saying they should be faithful to the law, but it does say they shall maintain professional competence in it. A judge shall not be swayed by partisan interest, public clamor, or fear of criticism. Number 3 says a judge shall require order and decorum in proceedings. A judge shall be patient, dignified, and courteous to litigants. It says litigants, jurors, witnesses, lawyers, and others with whom the judge deals in an official capacity and should require similar conduct of lawyers and of staff, court officials, and others subject to the judge's discretion and control. It says a judge shall perform judicial duties without bias or prejudice. Shall. That's a requirement. A judge shall not, in the performance of judicial duties by words or conduct, manifest bias or prejudice. They shall not knowingly permit staff, court officials, and others subject to the judge's discretion and control to do so. They shall not permit staff, officials, or others to manifest bias or prejudice, like the many times that Mallory Maddox, Ken Harder, Brooke Folks would be emailing about the case as soon as I would chime in and ask a request, like for instance, please confirm that I am going to get new counsel. All of a sudden, Mallory has no answers. She doesn't respond, and whatever request I'm making doesn't matter. The attorneys are responding, and she's all over conversation. They shall not permit their staff to manifest bias or prejudice. A judge shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to the law. This is Canon 3, B8. A judge shall not initiate, permit, or consider ex parte communications or other communications made to the judge outside the presence of the parties between the judge and a party, an attorney, a guardian or attorney ad litem, an alternative dispute resolution neutral, or any other court appointee concerning the merits of a pending or impending judicial proceeding. A judge shall require compliance with this subsection by court personnel subject to the judge's direction and control. Again, that has continued to be violated. Trying to get through this because honestly I'm kind of tired of sharing all this information. It's 3 years that I'm trying to put into 3 weeks, and it's just a lot, and I shouldn't even be in this situation. I found out that we lost our storage and our entire lives while I was forced on the road to protect my life while they're showing up with officers and guns drawn looking for me and Mariah. And so I'm actually getting a little bit aggravated and angry that I'm even having to live like this, burning through money that should have been going to my children. So honestly, I think I'm probably getting to the tail end of just, you know what, trust God, put the truth out there, and let the chips fall where they may. I am going to go ahead and cover fiduciary duty, which includes such relationship as executor, administrator, trustee, and guardian. This talks about knowingly, knowledge, known, or knows, denotes actual knowledge of the fact in question. A person's knowledge may be inferred from circumstances. Law denotes court rules, as well as statutes, constitutional provisions, and decisional law. This is, what I'm reading is actually still under terminology. That's on page 10. What I'm reading now is page 11. 11 here states require. The rules prescribing that a judge require certain conduct of others are like all of the rules in this code, rules of reason. The use of the term require in that context mean a judge is to exercise reasonable direction and control over the conduct of those persons subject to the judge's direction and control. Senior judge means a retired appellate or district judge who is consented to be subject to assignment pursuant to section 75.001 Government Code, chapter 359, 69th Legislature, regular session, 1985. I believe that was Judge John Roach Jr. for a period of time, and I believe now that's Scott Becker in Collin County. All right, I'm going on to section number 2 here in this binder. And this is the Texas Lawyers Creed, a mandate for professionalism. Again, you can Google and find this. One of the things that I thought was really interesting and that I read immediately with my attorney, Brooke Folks, when she mentioned that she would not address the fraudulent court-tampered email saying that Mother didn't appear, was that I actually went through the creed, and before I was even going to get upset with whether she did or didn't do what she was doing, I said, let me read the creed and see what she's supposed to be doing. And this is the first time that I saw in section 2, lawyer to client, says a lawyer owes to a client allegiance, learning, skill, and industry. A lawyer shall employ all appropriate legal means to protect and advance the client's legitimate rights, claims, and objectives. A lawyer shall not be deferred by any real or imagined fear of judicial disfavor or public unpopularity, nor be influenced by mere self-interest. When Brooke Folks says, you know what, I'm not going to bring into account the fraudulent email chain because I still have to practice in Collin County once your case is over, and Judge Miskell is on the bench till 2020, she's unopposed, so sorry, the fraud's not getting in. Lawyers Creed says, can't focus on your self-interest or any perceived or real threat of retaliation. Again, if she's against judicial activism, or if the attorney, right, that knows Emily Miskell is worried about retaliation, she just said a whole lot more about her character than I ever could allege or imply in making these videos and just releasing my experience. So this is where I'm going to go into directly while again talking about Brooke Folks and her issues about allegiance to her client. Well, this is an email chain that she gives to Ken Harder, where in her words she's saying, as I know, we discussed my withdrawing from the case. I was about to file the motion to withdraw and realized it would delay this entire case because Judge Miskell is not hearing motions on this case until 2/9. I'm trying my best to stick with it and simply want what is best for this child. That's a load of crap. This is by far the hardest case I've had in terms of dealing with a client. Hopefully, by me staying in the case, it makes it a little easier on you. I'm going to go ahead and show this entire email so you know what I'm reading. She is talking to Ken Harder, opposing counsel for Caree, murder threatening, child kidnap threatening, physical neglecting, secreting, child abusing Johnson, okay? She's writing this to his attorney. Hopefully me staying in the case will make things easier for you to convict Marlene Yvette, who's supposed to be my client. So again, just so you can see that there, this is Sonia Turner's self-authentication. Thank you so much, letterhead. from Brooke Folks to Ken Harder on Wednesday, January 6, 2016 at 12:02 p.m. But she wasn't making them ever finding that. This is another email that she had communications with Ken Harder, and she's asking that this be confidential between them. And of course, I'm asking, what interactions have you had with him? Please disclose that. Please provide all that information. And, she's saying that she hadn't heard from him much. Here, I just want to mention this really quickly. Ken Harder writes to my attorney on December 24, 2015 at 8:42 a.m. He says, honestly, I think there are some significant mental health issues here. I will not oppose your motion to withdraw and wish you well in the coming year and behind. It's saying, Marlena simply refuses to obey the order even after being admonished in open court that she is expected to follow it. Again, expected to follow a legally void order. Doesn't matter. I'm not going to follow a legally void order. And if he thought that there were some mental health issues and he's worried about the best interest of the child, he probably should have brought that up. Except he knows that there's no mental health issues, except the fact that I'm mentally strong and I'm not going to continue to go along with the court-sanctioned abuse and neglect of my children and or their conspiracy for my murder or where he drafts upon the death of Marlena Yvette. So I just thought that was interesting as well. This is a duress email that I received from Brooke Folks to force me to agree to her filing an answer which would commit me into the case. This was actually done Thursday, February 4th, 2016 at 6:39 a.m. And this is me immediately contacting her back with regards to, let's see, actually this is February 4th, which is 5 days to my final trial. This is addressing the duress to file an answer, her prejudicing my case and not returning my file, and her denial of collusion conversations with Ken Harder. This is actually, from Brooke Folks. This is her. This is her case sheet of all the motions that have been filed in this case. One of the things that I thought was interesting is when we go down the list here, you've got all the dates. What I thought was ridiculously interesting is where, we have an order. It says from 9/9/2015, which is NOH on motion for temporary orders, notice of hearing on motion for temporary orders, and then the next thing is motion for enforcement of possession and access on 11/10/2015, listed there as her line number 8. Then we've got 11/10/2015, number 9, order to appear, but what we don't have in between September 9th, 2015, which is line item 7, and what we don't have in between motion for enforcement of possession and access on 11/10/2015, which is line number 8, is we don't actually have the temporary order. We don't have the one document she was appointed by the court to defend me on. We've got all these other documents. And again, just like with Ken Harder, neither one of them actually include the temporary order in their pleadings. And they don't include it because they understand that the order is void. It is a void order in the matter of the marriage of, which is a suit that does not exist, is not ripe, therefore it cannot be enforced or held in contempt. And I just thought that's funny that she was hired for one purpose and one purpose only, right? And that's to defend me on the contempt, alleged contempt of possession and access for the temporary order that was signed on 10/8/2015. However, when you look at her entire case file that she put together, she does not even have the temporary order listed anywhere in line items 1 through 21. Interesting. So again, what was she retained to do? Oh, I forgot. Make it easier for Ken Harder to get through this and convict me with her buddy Judge Emily Miskell, who called her off the family court secret wheel. Okay, so this is talking about service of documents for Corey Johnson when he was served. Oh, I'm sorry. No, actually, this is me asking for service of the documents because Ken Harder always likes to draft fraudulent pleadings that he doesn't want to serve me on. And me actually saying, hey, I requested information from your process server to meet him. I'm not evading arrest. I do have Texas address confidentiality protection. And before Judge Miskell just randomly removed my protection and told Corey Johnson exactly where to find me and my children, the man that's threatening to murder me, I was actually... he would go to my mailbox there in Allen. They would give me the number. I would call his process server immediately and arrange to meet. So I was not evading arrest. I wasn't slamming doors on process servers like his mother, Norma Taylor, as in the affidavit when she was served to come to court the second time. I was cooperating. But ultimately, doesn't matter. This is just a case I pulled up on Ken Harder defending someone, looks like a Juan Miranda Martinez, that was guilty of sexual assault with a child, sexual assault with a child, indecency with the child, sexual contact, 3 counts, so 6 counts. Looks like he zealously defended this person for about 2.5 years, but finally wound up pleading guilty as he was in the beginning, and so, again, apparently he likes to defend pedophiles. Okay, so, next, this is why also the final order is not a valid order. This is me saying that, you know, he attempted to depose me outside of the discovery timelines, and me saying, you know what, I'm not trying to be combative, but if I'm incorrect, please let me know. I'm just trying to get clarity. And then on Friday, January 8, 2016 at 12:38 p.m., Ken Harder states, I'm not agreeable to a Schedule 3. I see no need for that. I think it's in all's best interest to resolve this case as scheduled. The interesting thing about it is this pleading said this case is to be conducted under Level 3. Those are prerequisites. A discovery control plan, all cases must be managed by a discovery control plan. He asked for a Level 3, and now he's saying he's not agreeable to 1. So he's either the one with the mental issues and the bipolar, can't decide which side of the fence that he's on, or again, skip the facts, forget the legal prerequisites, it doesn't matter. Me, Collin County, have already decided, Marilyn Yvette, you lose. Let's just move forward to trial and get this out of the way so we can go ahead and illegally kidnap the child, give her back to Crete Johnson, make your life a living hell, and hopefully silence and shut you up. Forget the pleasantries, but ultimately just letting y'all know that this is actually a procedural issue as to why we could not have had that final hearing in the first place. We had no Schedule 3 discovery control plan as he pled for. Nothing was signed. No mediation was held. So again, when they violate due process, their orders are not voidable. They're just void. Again, I am not giving legal advice, but I'm explaining what has happened in my case. First Amendment right. Proposed agreed order now needing to include the counterpetition to modify post the motion to dismiss. This is where, ultimately I'm trying to resolve this case with Ken Harder. Thank you, Protective Parents Coalition out of Tarrant County, Tarrant Families Matter. This is actually just something that I got while I was just before getting on the road. 2/29/2016, it was educating about the family court secret will. It actually states that, again, Texas Government Code, Section 37.005, posting of list. A court annually shall post each list established under Section 37.003 at the courthouse of the county in which the court is located and on any internet website of the court. So when you get a court-appointed attorney, this admission of Brooke Folks of, Emily called me off the wheel. I didn't know what she was talking about. Thanks to Protective Parents Coalition, I now know what she was saying is that she didn't qualify to be an attorney that's assigned to cases because she didn't have enough experience yet. She didn't have enough ethics and standards yet for people that are given the Sixth Amendment right to effective counsel and representation when they're facing criminal charges. She didn't qualify. So why she felt that was cute to let me know that, I'm thankful. But ultimately, thanks for letting me know, Protective Parents Coalition, about the family court will. My court-appointed attorney that was working with opposing counsel to make sure I was convicted and make it easier on him to make sure I was convicted unlawfully, yeah, she wasn't on the wheel. This is actually going through her enforcement trial. She had 4 motions. It was the temporary orders, the Dallas Central Appraisal District, a photograph of me with my kids, and an email from me to Crete Johnson about my accident on 10/16. After we talked about all these witnesses, all these legal defenses she was going to do, and she didn't follow through with it, came down to the spelling of the street name in the order signed on October 8th was Rust Town, 2 words, and Dallas only has a Rust Town, 1 word. And so it was not enforceable by contempt because it wasn't clear enough. She didn't know where to drop off the child that she dropped off 3 times. That was going to be Brooke's defense for me. So yes, when I asked her at the hearing, what have you prepared for me? And I saw she was going to argue the street name and a picture of me and my kids and an email that I sent to Corey that I was in an accident that he ignored, not the records that she should have subpoenaed from the hospital to prove the accident and the violation on 10/16. But when I saw it got down to the street name that I was able to give Brooke to subpoena Norma to drop the child off 3 times, drop my daughter off. Now she's going to say you can't hold her in contempt because the street name was messed up. Well, one of 2 things happens in this regard. 1, I was going to lose on that being bogus, or I was going to win. And if that's all it came down to. How did I get convicted in an order in the matter of the marriage of, with all of the other issues that were not clear, that were not specific, violations of due process and fraud? If it just came down to they put a space and an additional T in the name of the street, and that's why I can't be convicted, then it's obvious to know that that is a suit that was groundless and frivolous and shouldn't have been brought in the first place. Or again, she wasn't going to fight that hard for me, which is why I said, no, I don't want Brooke to represent me. Your Honor, I do want effective counsel or more time to prepare for my case, because I've blown 2 weeks with her shenanigans and her foolishness. And of course, in the final order, fraudulently, it states that mother requested to represent herself. Again, I did not. Thank God, again, my pastor even put in his affidavit that he recalls me asking for an attorney or a continuance, and the judge, again, denying it. Doesn't matter. Forget the pleasantries, Marlena. We're just going to move forward and convict you. The whole aspect of clarification of an order being crystal clear before it can be enforced. When they alleged this against me with my son, back June 18th, 2015, 11:15 a.m., they actually did give me effective counsel, which was Brandon Epperson, and he did file that the order sought to be enforced by Movent is incapable of enforcement, and that is ambiguous and is not clear and specific enough in its terms that respondent knows what duties or obligations are required. This is an issue that I mentioned to Brooke Folks early on, and that's in the emails that you'll see. Again, certified document when Brandon Epperson filed it. This is also file turned over by Brooke Folks. That is my son's case. Okay, well, I'm sorry. Let me see where I can show where she... Okay, these were turned over by Brooke Folks, where she actually writes son's case, because I told her, hey, if you go look at Brandon Epperson's pleadings, you'll see where he's saying that the previous order that I had in that case wasn't clear enough to be enforced by contempt, and maybe you can mimic what he's doing. So she knew, and this is where she wrote son's case. So apparently she pulled this out of her attorney system on 12/8/2015. So she had this early on, the option to do this, and of course never filed it on my behalf. Now we're going to talk about the white paper that she had that also is further research about why I can't be held in contempt. It says an example of one count of failing to pay child support and a motion for enforcement may read as, on February 14, 2009, in cause number 1234, styled in the matter of the marriage of John Doe and Jane Doe and in the interest of Johnny Doe, a minor child, in the 325th Judicial District of Tarrant County, Texas, this honorable court signed an order that states in relevant part as follows. Now, obviously that's not my case, but the relevance of this is that when you're trying to enforce an order, you need to reference the order that you're enforcing. That should actually be attached as an exhibit of evidence of this is what was ordered by the court. And of course, she didn't do that. Ken Harder didn't do that. She didn't plead that he didn't do that, because the reason Ken Harder didn't put the order in is because we'd have to get confused with the facts that that's a void order in the first place, and so there's nothing for him to enforce. So again, I'm thankful for this white paper about child support enforcement and possession and access, also dealing with visitation, possession, and access. I'll show you the beginning of it. Child support, enforcement, and possession. It talks about community supervision. It says, if a respondent is found in contempt and sentenced to jail, the court may suspend the sentence as long as the respondent complies with certain conditions. Texas Family Code 157.211, the conditions imposed on the respondent may include reporting to a community supervision officer, allowing a community supervision officer to visit the respondent at the respondent's home or elsewhere, obtaining counseling on financial planning, budget management, conflict resolution, parenting skills, alcohol or drug abuse, or other matters causing the respondent to violate the order, paying child support and arrearage, paying court costs and attorney's fees, seeking employment assistance services through the Texas Workforce Commission, and participating in mediation or other services to alleviate conditions that prevent the respondent from obeying the court's order. Again, these are all of the things that I'll keep reading. The initial period of community supervision may not exceed 10 years. Texas Family Code 157.212. The court may continue the community supervision past 10 years to the earlier of the second anniversary of the date on which the community supervision first exceeded 10 years, or the date on which all child support, including arrears and interest, has been paid. One, there was no conditions to my quote-unquote community supervision because, again, it was bogus that I was found in contempt for it in the first place. That's another thing that does not exist even in the final order that they did not do per the Texas Family Code, so that's another issue. How did I violate something that never had any conditions to move forward with? It says motion to revoke community supervision. Unfortunately, quite often a respondent who has been placed on community supervision fails to live up to the conditions required in the supervision plan. When this happens, you can ask the motion supervision be revoked. A motion to revoke community supervision must be verified. Texas Family Code 157.214. If the motion itself alleges a prima facie case for the revocation or suspension of community supervision, an arrest warrant may be issued. Texas Family Code 157-2015. Once the respondent is arrested, a non-jury hearing must be held no later than the third working day after the date the court becomes available, but in no case should it be more than 7 working days after arrest. Texas Family Code 157-2016. All right, so to contempt or not to contempt. This is talking about alternatives to contempt. Before filing an enforcement action that requests contempt, several factors should be considered. Obviously, people need to pay their child support and allow possession of the child, and if they do not, they should be held accountable. But is incarceration always the answer? Upon being served with the motion for contempt requesting jail time, some respondents do everything within their power to raise the money to at least pay something towards the arrearages. Jail is a great incentive for people to pay. If the respondent does not pay, then it appropriately punishes them for the violation. I'm going to go over some other things here.